to determine who is the owner of land, the only way to determine ownership of land is when there is registered legal documentation, and those documentation are title documents registered either under the common law system, where there are deeds associated to illustrate ownership or to confirm ownership rather, and then the RPO system or the RPA system, where the certificate of title and other memorandums will assure title or speak to who has the interest, right, and ownership of the land, and in what manner.
Okay, that is, so you said a lot of things there that we probably need to clarify in terms of, you said common law system and RPA or RPO. For our listening audience, we may have some people that very much understand those terminologies, but what is the difference with the common law versus the RPA, and which one is the stronger defense, and why?
All right, so I'll go to the first question.
About 3 questions in one.
So firstly, the systems of registration just speak to under which legal arrangement the registration of your title documents fall. When we speak of the common law system, and this is something I realize that even young attorneys may have some difficulty with wrapping their mind around or understanding. The common law system of registration is governed by the Conveyancing and Law of Property Act. And in that act, all the transactions, the sales, the types of deeds, etc., is covered in that act. In fact, if you go to that act, it speaks of not just the contracts in relation to the transaction, namely sales agreement, etc., but it speaks of the different types of deeds, from the construction of a deed to understanding the wording, construction of it, implied and expressed terms, etc. That act also speaks of easements, receipts, part in the deed. It speaks of deeds of release and rent charges. It explains in thorough detail covenants and restrictions as it relates to deeds. There's an entire part about mortgages. There's an entire part about statutory mortgages and leases, rent charges, powers of attorney, and all the different types of documents that fall under the common law system, right? And that is what we speak of when we talk about common law documents. I don't want to say common law title because sometimes that confuse people, but it's really common law title, right? But it's under the Conveyancing and Law of Property Act. That's considered the common law system. You will have a deed number assigned to it, and all the transactions therein are referred to as deeds. If you are continuing to stay in that system, any subsequent transaction after has to be deeds. So you will have, if you have a deed of conveyance and you want to take out a mortgage, you'll have a deed of mortgage. You wouldn't have just a memorandum of mortgage just like that. It will continue within a deed system. So deed of conveyance, deed of mortgage, deed of release, deed of transfer, deed of gift, you go on. Then you have the RPO system, or the RPA system, which follows the Austrian torrent system, which is a registered and assured title system, where there is a guaranteed by the state registration of your land and the actual transaction itself. Unlike deeds under the common law system, which is executed and certified by an attorney at law, the systems under the RPO is actually assured and endorsed and governed by the registrar. Very, very important. And so if you look at the back of your certificate of title, you will see that each and every single endorsement to the back there is signed and entered and date and timed. You will even see the time that the registrar would have endorsed this. And it is a very much more serious types of transaction. There are only 2 copies of a certificate of title, sorry, and that's why if you lose it, it is a very tedious process to go through making a loss grant application. You have to get the police involved, all sort of things, because only 2 of those documents exist. One is kept at a vault at the Registrar General's Department, and one is given to the licensed donor. And so that system, if you were to say strength, I wouldn't use the word strength, because the second question you have, which is stronger, which is more secure, obviously will be the RPO system. It does not rely on the recitals or the story or the details about itself. It does not rely on trying to prove title. Proving title is a lot easier under the RPO system because all the transactions are recorded properly and it is assured by the state.
Excellent explanation. Go ahead.
I wanted to say including even debts, right? So this is something I also wanted to highlight. When you have a normal deed of assignment, and a deed of assignment is a gift that you say, but I want to retain a life interest. And upon my death, I want to assign my interest onto somebody else as the remainder man. Something like that. Remember, if you look at that type of transfer itself, it is literally dependent on the person's death. So the action or the occurrence that validates that the interest has passed from one person to the other, that occurrence is death needs to happen. Under the common law system, you could just say the person died. Like there is nothing that happens when the person dies. You just know the deed is yours now. And if you go to do anything with it, you just present the person that certificate and they say, well, they died. That is not the case with RPO. With RPO, you have to endorse the person's death on the CT. You have to make a death endorsement. Whereas under the common law system, let's break that down for what I mean, right? If I were to give you a deed of assignment, say I want to keep this house for the rest of my life, and upon my death, I transfer it to you. And then you now want to use that deed to mortgage it, or you want to sell it to someone else. When you are doing your subsequent transaction after my death, God forbid, I don't want to call that on myself, right? You need to simply recite that I would have died. And then go on. Just state the date of my death in the reciter, and then go on and whereas so died on whatever so dates, and I am now the sole owner, I now hereby convey on to, and you go ahead with your conveyance. And it is the responsibility of the person purchasing from you or the bank mortgaging to check if these things actually happened. That is what happens under common law. You simply recite what happened and you go on with your life and you register the document. The Registrar General is not going to check the form of that. They're not going to check to see if I really die, and so what title is not investigated. Whereas that is very different under the RPA system, where if there's a life interest to be retained, you must endorse and prove the death of the life tenant. That's how you are referred to. And only when that is registered and endorsed and proven, and you also give certain other evidence of the value of the property and all these things, land assurance. After that, you could then do your new transaction. And so they confirm it's not merely you just recite and you go ahead. You have to make sure that all of these things are done. And you see the same meticulous care is taken with RPO for subdivision. Under common law, you could just cut your deed. You cut your land and you give this one. You cannot do that under the RPO. You have to make sure you get approvals for subdivision before going ahead and cutting up your land. So everything under the RPO is a lot more regulated and certified, and lots of care is taken for transactions under the RPO.